11466, Commonwealth versus Renee Torres, and 11463, Commonwealth versus Davila.
Thank you.
Good morning again, Your Honors.
Morning.
Vincent DeMore on behalf of the Commonwealth. May it please the Court.
Can I ask you a question?
Please.
Assume hypothetically that this court were to say in these cases, well, the ones except for, well, these ones anyway, that the withdrawal of the guilty plea was okay. What happens? What are you going to do on a what would you do on a retrial?
To try the case again?
Yeah.
Practically speaking, we would submit the drugs for reanalysis. As
You
obviously
have them all?
I believe, as I said, and it's not. I know it sounds like an exaggeration, but I promise it's not. For Boston, at least, which is the lion's share of our cases, it's in the neighborhood of 95% of all the drugs are still available, going back to 2006, 2005. So we would resubmit them for analysis, and if we elected to, we could proceed forward with trying the defendant.
So you would not try, and then that obviously gets into the question about does it make any difference about the reanalysis, but
Sure.
We've talked about that. But you would not try to say, well, Annie Dukin was only the confirmatory chemist on these, and we have a primary chemist, and he or she can testify. You wouldn't do that.
No, we wouldn't elect to tie one hand behind our back proceeding into trial. We'd try to take the path of least resistance with respect to the fact finder there, and would certainly submit them for reanalysis. And I'll let the court know on cases we have submitted for reanalysis in terms of because there is this notion that this defense at trial is a cure-all. And in Suffolk County, we've tried 10 cases, 10 drug cases since this occurred. 8 of them were convictions, including ones where she was the primary chemist, and we resubmitted them for analysis.
And at the trial, did the evidence about all the misconduct come in?
Yes, in fact, in the one I'm specifically referring to where she was the primary chemist and was resubmitted for analysis, the judge allowed everything to come in. We think perhaps a little too overbroad with respect to what was allowed to come in, but it was the full kitchen sink in terms of what came in, and the jury convicted in 11 minutes. To address with respect to the Ferrara case, and it isn't the case that I was finally brought up Ferrara, it was just that's the next place we were going. I think, and Justice Cordy, I think, brought this up. The question is, did the misconduct occur in the defendant's case? And if we look at Ferrara, and I think Ferrara itself is an instructive case, in that case, there were findings made with respect to the actions that the prosecutor engaged in, the actual assistant U.S. attorney. Following that finding, what we didn't have was all of that prosecutor's other convictions being vacated, and in fact, that prosecutor remains today an employee of the United States Attorney's Office here in Boston. So I think there's a huge difference between allegations where the individual engaged in some misconduct in some places, as egregious as it may be, versus misconduct that occurred in the defendant's case. And with respect to the voluntariness argument, I think really the question can be boiled down very, very simply as to whether or not the defendant must show that there was misconduct that occurred or that the misconduct occurred in their case. And I think when we look at Campidi, we look at Waters, we look at Ellis, our courts have already rejected this notion that misconduct that's not related to the case or doesn't have a nexus to the case itself is sufficient to result, and in those cases, those were trials, which is a substantially lower standard for the defendant to meet than a plea.
But I mean, couldn't one make the analogy between misconduct? This would be an argument that's better made in a case, well, Gardner, where Annie Dukin has nothing to do with, she's neither primary nor confirmatory an analyst. So, I mean, one could make the argument here that, in fact, she did touch these cases.
Oh, she certainly, with respect to the primary cases, I would
yes.
concede that,
So,
yes.
So, I mean, it's hard to draw this analysis to make Ferrara too much of a, I think. They're just very different kinds of cases.
I'm not sure I entirely agree that they are. And because what we have fundamentally is we have a person who would have had nothing else, if had the defendant not pled guilty, would have been a witness in the defendant's trial. And that's all she is. She's a witness. She's a very important witness. Obviously, it goes to a very important element of the offense, a necessary element of the offense. I'm not suggesting that at all. And presuming that the impeachment information or the evidence would be admissible at that trial, the defendant is in possession of wonderful impeachment evidence, the kind of impeachment evidence that every defense attorney, I imagine, must dream about, when they think about how a case is going to be tried.
And this is because the prosecution would be able to put forward a chain of custody, laying foundation.
That would be one of the...
First, that would be the prosecution's burden. You'd have to show a chain of custody.
Yes.
And if you were in possession of this information, you could establish a chain of custody?
Yes, I think so. And that would certainly be an area that the defendant would attack. Chain of custody as well as simply the straight-up veracity of Ms. Dukin. In many ways, she's no... I'm sorry, Judge.
Just a general question. Can you give us a ballpark figure for how many cases are affected by this whole situation?
Sure. Just to clarify the question, if affected means she was one of the testing chemists?
Yeah, either she was the custodial analyst or the
40,000 plus?
confirmatory. Are we talking 40, 50,000 cases?
We are not.
Well, doesn't David Meyer identify 40,200 something?
Samples. There is a difference between samples and cases. For instance, one of my colleagues at the office has a case where essentially an individual stole all the drugs out of the back of an ambulance. That case, I think, has 190 samples. That's one case. Not every sample that's tested results in criminal charges. For instance, PC buys don't result in criminal charges for that offense. If somebody finds drugs on the street, they call the police come, they take them away. That doesn't result in drugs, in charges. The drugs have to be tested to be destroyed. It's a part of the statute.
But I haven't read his report carefully, but does that include all of those? I thought it was actually, it's not just connected to defendants?
Nope, it's every PC buy, every death investigation, overdoses, every instance of found drugs. But in the short answer to the question for Suffolk County, because this is one place I have crunched the numbers on, it's in the neighborhood of 12,000 cases in Suffolk County. Wow. Over a 10-year time period, which based on the rest of the numbers, probably represents about 70% of all the cases.
Do you know anything, outside of Suffolk County, I'm not holding it to you.
Sure.
I just don't know if you have a sense.
I don't have an exact sense, but based on the general proportion of it, I think we probably have about 70% of the total in that neighborhood.
Is there any consequence that in each of these pleas, I assume the prosecutor, as part of the proffer of the evidence, proffered that there was a certification that indicated that the drugs were cocaine or heroin or whatever they were?
Well, I think as a practical matter, that's an unusual occurrence as part of the proffer.
The prosecutor doesn't need to proffer all the elements?
Well, you don't need to proffer that there was a plea. It's just pardon me, you don't need to proffer that there was a certification. It's that the substance was recovered was cocaine, a Class B substance.
Right, but the prosecutor probably wouldn't have said that if the prosecutor knew about this.
Just as a practical matter, it's not the way it occurs on a daily basis, at least in the district courts, where about 90% of our cases come from. It's typically a recitation of the police report, and that's the conclusion of the facts.
There's one of the cases, I don't remember which one,
Yes.
where there's a transcript of the plea, and I read it, and there's absolutely no reference to a drug certificate.
Yes.
But there is a reference that it was sent to
the lab?
To the lab.
That was when I would do pleas when I was in the district courts. That's what I would do. Is I would say that it was later analyzed and determined to be XYZ, a Class B substance, or what have you.
So you would know, you would have seen the.
Yes, you'd never make that representation, obviously, unless you have a copy of the drug cert. Yes, although, and it's a court-by-court question in terms of the culture of each of the individual courthouses. There are many places where the defendants would routinely plead prior to the production of a drug cert as well.
And is there any consequence in that the prosecutor made that proffer, but perhaps would not have made the proffer if he knew or she knew what you know now?
No, I would suggest not, unless there is a showing that that information is factually inaccurate. Underpinning all of this, when we talk about the certifications being tainted or the certifications being falsified, is this a priori assumption that indeed they are false. A liar can occasionally tell the truth. So if you have someone who has been accused essentially of perjury, which is what we have here, that does not mean that they lied
He's
all
been
the
accused
time.
of a lot more than that.
But fundamentally, it's a question of perjury. Fundamentally, it's a question of untruthfulness, of not telling the truth.
Tampering with evidence is just perjury?
It's not. It's not truthful behavior. I mean,
Well,
I guess what I'm saying is the flavor of the indictments
But
against
that's
her.
minimizing, I think.
No, and I don't mean to minimize it at all. I truly don't. I don't want the court to misunderstand me with respect to that. The allegations against her are very, very serious allegations. But the fundamental nature of it is that she lied. She lied about what she was doing. She lied on those particular instances with the certifications. She perjured herself with respect to testimony she gave at trial on those particular cases. There are a number of instances of untruthful conduct, which is fundamentally
Well,
what she's alleged to have done.
contamination would be more than just lying, wouldn't it?
Well, yes, but I'll say that the contamination was for the purpose of lying. It was a means to an end, in essence. That was what she needed to do in order to falsify the result. And I hope the court doesn't think that I'm trying to minimize with regard to that. Tampering with evidence is obviously a very, very serious problem and a very, very serious allegation. But with regard to what underlies the conduct, it's a falsity, yes.
But if the prosecutor's aware that someone has done this or has been said to do this in any number of cases,
Yes.
you're saying it would make no difference to the prosecutor as to whether or not to put forward or rely upon a certification from this person
No.
in establishing the case, because sometimes liars tell the truth?
No, I think the question was, does it make a difference with regard to the plea itself and whether or not the plea essentially stands up after the fact? What we have done is on cases where she was the testing chemist or one of the testing chemists, is we have ordered retesting on our cases, and we're proceeding with the retest. Obviously, if someone came into court today and asked to plead guilty on an Annie Dugan case, as so-called, we would essentially object to going forward on that plea.
Okay, so what I hear you saying is that the prosecutor relied upon the certification with regard to the proffer, but didn't the defendant also rely on the certification with respect to the plea?
I don't know.
And well, let's assume that a defendant can establish that if he knew what he knew now,
Yes.
he would not have pled guilty. Does that mean that the government's misconduct has in some fashion affected or induced that plea?
Only if the misconduct occurred in the defendant's case. If the misconduct occurs such that the tampering or the falsification of the result is the defendant's result for this particular docket number, that's what induces the plea. Absent a showing of misconduct in this particular case, there can be no sort of antecedent action which would induce the defendant to plead guilty.
And how would the defendant ever show that?
That there was misconduct in his case? Well, as I indicated before, the Inspector General's office is reviewing all 400,000 samples that were submitted over that 10-year time period, and whenever they find an anomaly, it's our understanding they're engaging in further investigation. And certainly the Attorney General's office found a number of cases over that 18-month time period. And with respect to my admittedly limited knowledge of how that review can be conducted, a review of the documents will show if something went through twice, so to speak. And it's those cases, if one takes all of the statements that Ms. Dugan made in terms of her admission, it would be those cases would be the cases that she would have tampered with the result on.
I thought that, I remember reading somewhere that in the month of June 2011, there were 90 cases
Yes.
that she did something, there was either misfeasance or malfeasance in about 90 cases just in the month of June of 2011.
She took the samples.
Yeah, I'm not sure which feasance we would put it under, but in that particular case, she removed she assigned herself, in essence, 90 samples from Norfolk County, and when confronted with this, denied it, and I think backfilled the log with the evidence officer's initials.
Right.
Okay.
Let's look at it from the point of view of a district court judge who's faced with this decision. You say, Your Honor, the defendant who's already pled guilty and is serving the sentence that was imposed can only withdraw his plea if he proves that there was misconduct in his case.
Yes.
He's saying, well, the IG hasn't even put forward their report. I can't do that realistically until my sentence is over. Is it your position that he has to wait essentially until his sentence is completed for all practical reasons before he can prove that he's allowed to withdraw his plea?
No, and I think those are two separate questions. Of course, the defendant can move, as this court ruled in the Charles case, that he can move to stay the execution of his sentence and be released from prison pending the determination of his case. But that's simply an option he has. It doesn't mean the court has to do it, of course. But that because the Inspector General is engaging in a review, that does not preclude the defendant from doing his own independent investigation of the documents and the like. All of those documents are readily available to defendants, and we are providing them in dozens or hundreds of cases, I should say, where, with respect to the backup documentation, the laboratory package itself. And then a review of those documents, I would suggest, should reveal whether or not there's any anomalies that would require sort of further investigation. And the defendant could, at his election, move for retesting, which, as I indicated before, not a single defendant has done. And I see my time is up, so unless the court has any further questions at this point, I'll
You'll be
rest my
back.
visa. Thank you.
Thank you.
Good morning. May it please the court, Dana Curhan for Renee Torres. I want to talk just briefly about materiality. We don't have an affidavit from the defendant. We have affidavits from his counsel, but they're kind of boilerplate and don't really talk about anything about the plea or the motion to withdraw the plea. But what we have is a very strong showing of materiality.
Can I?
Yes.
I know I'm interrupting you, but can you explain to me? We heard from Mr. Wood about why it matters that Annie Dukin was the primary chemist, and in these ones, she's a confirmatory chemist, right? And so, just explain factually
Yes.
why that, that's as significant as the fact that she would be the primary chemist.
I think confirmatory is probably not the appropriate word for this. What happens when they test the substance is the primary chemist does essentially a chemical test. It's
Right.
very similar to what
The sort
a
of
police-
preliminary, yeah.
like a field test.
Right.
It's not admissible independently. They pour the chemical on and it turns blue-green, and blue-green may mean it's cocaine or it may mean it's one of a number of other illegal substances or possibly some legal substances. At that point, it's then submitted to the secondary chemist who does the actual testing and identifies the substance as cocaine or
But
heroin or
But
whatever.
that's with the help of the GCMS machine, correct?
That's right. Now,
So what is the role of her as an individual?
the role of her as an individual is to properly test and run the machine, and that includes a lot of very technical things, testing and running a controlled sample and making sure that the vial that that person received from the primary chemist is properly compared to the control.
And so what's the opportunity to mess it up at that point?
Oh, plenty. First of all, Ms. Dukin was doing the testing, and the testing, the initial calibration and testing is so important that two chemists actually have to do that testing.
So if
and
there's
have to
another
sign up
chemist
on it.
there, wouldn't that suggest
Well,
it was okay?
here's the problem. Ms. Dukin would sign her own name on on her own initials, and then forge the initials of another chemist, including Nicole Medina, who was the primary chemist in this case.
Has that been found to be a fact in this case, that the second chemist's initials were forged?
Yes, she has admitted doing that.
No, but not...
In this
but-
particular
no,
case?
not in this
In this particular case,
Torres's case?
in Torres's case, no.
Okay.
We're not sure.
Okay.
But so you're saying, like the primary...
That's
There
right.
are certain instances where you know she did whatever she did, but so you can assume it's a lot more, and you're saying here, there are certain instances maybe not this one in particular, that you know that she signed other people's initials, or she was doing that quality control thing really on her own. She didn't have somebody else there. Is that what you're?
That's what
and
I'm.
we don't know that it was this case, but we don't know that it wasn't.
That's right. And there are other deficiencies in what she was doing. There are other tests that she has to perform. She has admitted that she was tampering with the samples. She has also admitted that she, on her...
These wouldn't have been her, but I take it that tampering is for when she's the primary chemist, no?
Well, what she can do is take some of the stuff from the vial that she gets and mix that in with the control. And she was messing up with the control. She was doing things like that with the control, so that it wasn't actually a controlled sample going through. It was actually a...
Is the control preserved?
I don't think it is, no.
Okay. Was she also accused of tampering with the calibration of the machine or certification of the
Either
machine?
tampering with it or just not doing it, saying she did it and not doing
And
it.
how often does that have to be done?
I'm not sure. I think it's at least daily.
Okay.
And I'm not sure if it's before
It's not like
each
every
test.
6 months, or?
Oh, no. That's something that has to be done, and there's a log kept, but she was...
And does anybody, is there any backup verification? Does somebody have to
Well,
witness?
there's supposed to be 2 people doing that. And she was doing it and then forging the other person's name. There was also, she also admitted to one instance where she so-called dry lab. She took a sample, there was a sample that had already been sent back that she essentially forged the results. And we don't know how often she was doing this.
As the
That's
confirmatory or as the primary?
As the secondary, that she sent one back and wrote in false results on a sample that had been sent back to the police station 6 months earlier. So, you know, we cannot trust any result that she came up with as the secondary chemist. I think it's probably the difference between being a primary chemist and a secondary chemist is a secondary chemist, maybe you can go back and retest because she's not the primary custodial chemist, so I think if we're going to look at a global solution, I think maybe you reverse all of these, vacate the convictions, and then the Commonwealth has the opportunity to come back and retest it and show that perhaps it wasn't tainted, setting aside everything that happened generally in the lab.
Yeah. Is the secondary, there are 2 people on the confirmatory end, I take it. Are they always in the presence of one another while that confirmatory testing is being done?
No, but I think there's one person that does the secondary testing.
Yeah.
But as far as calibrating the machine, it's got to be 2 people.
At the same, in the presence of one another?
I'm not sure in the presence of one another. I know that there has to be at least 2 people, but I'm not sure if they have to be in the same room.
Okay, but only one of them is needed to actually operate the machine for purposes of testing a sample and a control.
Right, one of them operates the machine. Let me just talk very briefly about Rene Torres. He was stopped for a motor vehicle violation. The officer asked him if he had any contraband or weapons in the car. He said, "I have some weed." They searched him, they found the marijuana. They then did an inventory search of the car and they found 1 packet of cocaine, of suspected cocaine. He was not seen dealing. He did not admit that he had it. He did not admit that he knew what it was. So I think clearly the only evidence of his guilt on the
So all he's charged with is possession.
just possession. The only
So isn't this a perfect case for him to scream out at the time of the plea, "Hey, I didn't have cocaine"?
he really should have. He unfortunately this
So
was,
there's no affidavit to that effect. It almost, and again, I'm getting back to this idea of the flavor of that you get from the lack of an affidavit. There's a sense that there's a very strong inference that can be drawn that he knew he had cocaine. Otherwise, he would have complained about it. I'm being unjustly accused of having cocaine. He's never said anything about that.
What happened is his motion was initially denied. There was a motion for reconsideration that included some other things, and one of those things was the police report. And when I think maybe the judge looked at this police report. Unfortunately, we don't have findings, but when the judge looked at this police report, there it is. The only evidence of his guilt was the certificate.
Now, he also pled guilty to unlicensed operation.
Yes, he did.
And was that withdrawn too?
I'm not sure if that was. I don't think it was. I don't think that was an issue in this case.
Well, counsel, your time is up.
Thank you.
Thank you.
May it please the court, good morning. My name is George Gormley, and I appear on behalf of Adam Davila. Mr. Davila was sentenced in the federal court as a career offender, and shortly after that sentence was imposed, I became aware of the misconduct at the Hinton lab, and shortly after that, I became aware that there was that Ms. Dukin had signed each of the two certificates that were an issue in one of the cases, in a case which Mr. Davila had pled guilty and which was used as a career offender predicate.
And you were the trial counsel who filed the affidavit with the state police report attached?
I was the, yes, I filed that affidavit.
And you also filed an affidavit saying that if I had known what I know now, I would not have advised my client to plead guilty. Didn't you?
Well,
isn't that your affidavit?
I was, well, I did not, I was not his lawyer at the original plea. Okay. I was, the affidavit which I filed that listed off and attached all of the state police reports which I had, that it is my view that no competent lawyer, given the situation, knowing what the situation is with Ms. Dukin and the lab, would have given that advice at that particular time. But as I was listening to the colloquy between the court and previous counsel, I would say that when I filed my motion to vacate, or Mr. Davila's motion to vacate, I made an effort to get the matter before the judge who took the plea, as opposed to there was some indication that there was going to be special magistrates or somebody was going to be doing this in Suffolk County. There was nothing definite, and I thought that it made most sense for the judge who had sentenced him to hear the matter, and and that's where the case was brought back. When I filed the papers, the Commonwealth requested on 2 occasions an opportunity, a continuance. I filed, I think, in November, and on 2 occasions the Commonwealth requested a continuance to respond and to prepare. Nothing was submitted until I think it was January 21st or 22nd. There was no, when the Commonwealth filed a brief which said that a plea of guilty is a break in the chain, and that should be it. But there was no evidence submitted. For example, Ms. Medina, who was also one of the chemists, was presumably available to submit an affidavit regarding the propriety of the tests in this in Mr. Davila's case. There was nothing submitted, nothing factual submitted, And based on that, and based on the trial court judge's recollection of the case.
Tell me a little bit about the case. Your client was charged with distributing both heroin and cocaine, correct?
That's correct, Judge.
Were those charges broken down at the time of the guilty plea to something less than that?
I do not know, and there is no, the tape had been destroyed by this time. But the certificates encompassed both of the categories of drugs, and were both signed by
I don't think,
Ms. Dukin and Ms. Medina.
I don't recall that those charges were broken down, that those were the original charges, distribution of cocaine and heroin, I think. But- Maybe, but anyway, I didn't mean to derail you.
There's a count for distribution of Class A, and then there's a count for distribution of Class B. Now,
And the recommendation was a period of probation? Was that an agreed-upon recommendation, do you recall? I'm just trying to get a better sense of what happened at the plea and why this would have made such a difference later on.
well, the reason for that, Judge, is there was a motion to suppress which was filed and decided adversely to Mr. Davila. And then thereafter, there were plea discussions, and I believe the records suggest there were, the matter went before a couple of judges before Judge Coyne imposed the probation. But the reason, this was all before Melendez-Diaz came down, and I think is your recent case, after I filed my brief, Ramsey, where you discuss the paramount importance of a drug certificate, and in a case such as this, which where there was an opportunity to remain on the street, and powerful evidence, which I believe is the way you characterize drug certificates, which prior to Melendez-Diaz was the whole case, if you will. That's why he agreed to change his plea, and thereafter it came back to impact him when he somewhere later on offended and was brought into the federal court.
Okay, appreciate it.
All right, thank you very much, sir. We're going to take a brief recess.